Welcome back to another J. Harris Academy of Police Training Roll Call. I'm Joey Sperlazza. Today we're going to be discussing State of New Jersey versus Jonathan Lightsey. This is a New Jersey Appellate Division unpublished opinion that was decided on April 8th, 2025. Take a look at that picture right here of this Infiniti. That Infiniti was backed in between two tractor trailers with that sunshade while the vehicle was occupied. We have two Elizabeth officers that were sitting there watching that vehicle. Those narcotics officers were patrolling that lot known to be a high trafficking area. He observed a silver Infiniti with a sunshade covering the front windshield parked between two box trucks. He believed that the driver was trying to disguise the vehicle based on its location and due to the way that it was backed in between the two box trucks. As he was circling the parking lot, he noticed a female, known as a narcotics user, conversing with the driver of the vehicle. The officers observed the female hand the driver an unknown amount of currency in exchange for a small item suspected to be a hand-to-hand narcotics transaction. When they were asked why they didn't stop the purchaser, Officer Kinnery stated, "We didn't want to jump the gun yet. We wanted to wait and observe more. We had a good position and we stayed within our nondescript vehicle." They didn't have any backup at that point. There weren't any narcotics detectives in the area. After the second transaction, the officer ran the vehicle's license plate and learned that it was registered to the defendant. The officers knew of the defendant based on a prior investigation where a search warrant had been issued. When the officers attempted to execute the search warrant on the defendant fled in his vehicle, which caused several motor vehicle accidents. Officer Kinnery decided not to move in while the defendant was inside the vehicle because we wanted to avoid a pursuit or putting any of the public in danger because that parking lot is very busy. Backup arrived and surveillance continued for approximately 40 more minutes. A third female approached the vehicle, engaged in a transaction, and left the area in a Jaguar. Officer attempts to stop the Jaguar were unsuccessful due to heavy traffic. About 1 hour and 10 minutes passed between his arrival at the convenience store and his observation of the third transaction. Shortly after the third transaction, the defendant exited the vehicle and was identified. Officers then observed a female approach and utter something to the defendant, and they both looked in our direction and at our vehicle. We believe that our surveillance location had been compromised. The defendant walked across the parking lot and entered the rear entrance to the convenience store. Upon the defendant exiting the convenience store, officers moved in to prevent the defendant from entering the vehicle and giving him an option to flee. Officers detained the defendant, handcuffed him, and placed him in the rear of a patrol vehicle. Officers then searched the vehicle. He opened the driver's side door of the vehicle where he observed suspected crack cocaine residue scattered on the front driver's seat. Officers recovered about $660 in U.S. currency, low denominations consistent with street-level narcotics dealing from a search of the defendant's person. They also recovered 25 grams of alleged crack cocaine and 60 glassine envelopes from the defendant's vehicle. The trial court ruled in favor of the defendant. They relied on State versus Smart and granted his motion to suppress the evidence. The court found Officer Kinnery to be very credible, yet it found probable cause to search the defendant's vehicle did not arise from unforeseen and spontaneous circumstances because officers surveilled the vehicle for over 2 hours and witnessed 3 separate transactions. The state appealed. Just to quickly go back to State versus Smart. In that case, Kyle Smart was being surveilled as part of an ongoing investigation, month-long investigation. When they found him and they stopped him, they did a warrantless search of the vehicle. That search was suppressed because they said under State versus Witt, and looking back even to State versus Alston, they said that those circumstances that give rise to probable cause have to be unforeseen and spontaneous. It has to be a random stop. So here, what the defense attorney presented and what the trial court stated is that they suppressed that evidence because of the fact that this was an investigation for approximately 2 hours. So the state appeals and it gets moved up to the appellate division. At the appellate division, the state argued. They relied on the New Jersey Supreme Court decision in State versus Witt from 2015, arguing Witt permits warrantless vehicle searches after investigative stops when probable cause arises from unforeseeable and spontaneous circumstances. The state also argued the trial court's finding that the circumstances forming PC to search was not spontaneous or unforeseeable was incorrect, and the comparison to Smart is flawed, as the officers did not act on long-held information or conduct prolonged surveillance. Applying the facts of this matter to the legal backdrop, the state's argument holds merit. The sole issue raised on appeal is whether the circumstances supporting probable cause for the warrantless search of the defendant's vehicle based on the automobile exception was both unforeseeable and spontaneous. The state met these requirements by a preponderance of the evidence when viewing the totality of the circumstances surrounding the search. The uncontroverted testimony of Officer Kinnery provided undisputed evidence that the surveillance was not part of an ongoing investigation of our defendant. Law enforcement had no prior information about the defendant before patrolling and parking their police vehicle to surveil the vehicle. Up to this point, the circumstances giving rise to probable cause that the defendant's vehicle contained CDS were unforeseen. The convenience store parking lot was known by law enforcement as an open-air drug market. Although evidence connecting the high crime reputation of an area is permitted to be considered as part of the totality of the circumstances test in determining probable cause, the trials court finding that this general knowledge somehow equates to specific knowledge that the defendant's vehicle contained CDS was foreseeable misapplies the established legal principles of wit and smart. The automobile exception would be severely limited if the routine patrolling of high crime areas by law enforcement satisfied the foreseeability prong, obviating the probable cause to search a vehicle without a warrant under the automobile exception. The information obtained during 1.5 to almost 2 hour surveillance provided probable cause to search the defendant's vehicle, arose spontaneously, and was unforeseeable, justifying the warrantless search under the automobile exception. Requiring law enforcement to engage in an immediate stop and search of the defendant's vehicle after viewing one suspected transaction would place undue burden on the investigatory demands of law enforcement, which wit informs must be taken into consideration. To do so would place law enforcement in the unenviable position of deciding whether sufficient probable cause had been developed based on the observation of only one possible drug transaction. Viewing these circumstances through the perspective of the officers, their belief that probable cause was not fully developed after the observation of one possible transaction was reasonable. After the officers observed the second transaction, they had sufficient probable cause, which was both spontaneous and unforeseeable, to support a search of the vehicle. Their decision not to engage the defendant while he was in his vehicle was reasonable based on the defendant's previous eluding incident and the potential danger to officers and the public. The warrantless search of the defendant's vehicle was permitted under the automobile exception. The circumstances giving rise to probable cause for the search were both unforeseeable and spontaneous under the undisputed facts contained in the record. The appellate court ruled in favor of the state in this case. We have a good search under State versus Witt as well as State versus Kyle Smart. We have to remember, especially when you look at these cases, how long is this investigation? In this case, about a couple of hours. It was okay. It's an appellate unpublished opinion, though, so we have to understand what the mindset is behind these judges. It was still a fresh investigation. Let's say that this moved into the next morning and they saw him come back to the same parking lot again. They saw the same transactions from the same vehicle. In that case, it probably would have ruled under Smart, saying you guys should have applied for a warrant. This is now an ongoing investigation, even though it's back-to-back days. These are the type of things that you need to consider when you're in the street. When in doubt, get a search warrant. When we have a warrant, the burden will always shift over the defendant to show that the warrant was flawed, the probable cause was flawed, etc. There was no dispute in this case about the probable cause. The probable cause was excellent. The only dispute was, did he need a warrant or did we not need a warrant? So, great job by the Elizabeth officers. Excellent testimony by Officer Kinnery. We applaud your efforts. For more great content, subscribe. Stay safe.
This podcast is brought to you by the J. Harris Academy of Police Training. J. Harris Academy of Police Training is based in New Jersey and provides law enforcement training services nationwide for promotional examinations, use of force, supervisory development, and other key areas within law enforcement. This podcast is utilized to discuss key topics occurring within the profession. The opinions and information provided is for entertainment purposes only. In an effort to provide this, we often purposely discuss opposite views and opinions to spark conversation and develop discussion points. The contents of the show and show notes are all copyrighted. All blog posts, podcasts, and show notes that are distributed to the public for free can be redistributed via hard copy or electronic copy for free only if the J. Harris Academy of Police Training is included as the acknowledged author within the actual media that is redistributed. This entire disclaimer also applies to any guests or contributors to the podcast or blog. Under no circumstances shall the J. Harris Academy of Police Training, any guests, contributors to the podcast or blog, or any employees, associates, or affiliates of the company be responsible for damages arising from the use of the information provided.